Okay, my name is Abe Fuchs, and I'm doing a video on a corrupt court case of an election. Okay, so when I say corrupt, I don't mean that I found a smoking gun. I just mean that there was, it sure looks like there was undue influence from a Democratic Party to the judges, in the sense that the Democratic Party promotes these judges. So when the lawyers representing county, meaning the Democratic Party here in Queens, by the way, come in front of the judges that the party promoted, it's very hard for the judges then to go against these lawyers, because they're going against county. The lawyers are from county. Okay, now I just want to say that regarding this whole election denial, we hear the idea that Trump's claims went before 60 court cases, and we think, gee, how can all 60 cases be wrong? Well, procedurally, if they didn't even get into the merits, it's very easy for them to be wrong, because procedurally they can throw things out very easily. This is what I want to show you of a case that was, in my opinion, corrupt procedurally. Okay, now just to give you a little background, I ran against, I was putting in petitions to run against an assembly member. I'm not going to go into who it was, because I don't want to make this a campaign thing. But I'm a centrist Democrat. Actually, I'm kind of both a centrist Democrat, a centrist Republican. Actually, I probably should be an independent. Maybe I will be someday. But I wanted to run against this person because they wanted to promote felons voting from prison, and trans women being the same cell with biological women. In other words, a biological man who says he's a woman, trans woman, to be in a cell with regular women. And she also believed in cashless bail. Okay. So I'll read some, and I'll comment on my own, and I'd like to read from the court transcript also. So this past spring in the March of 2022, I ran the primary for the New York State Assembly. I joined a petition team to get my name on the ballot. That team had an election consultant, and I was not in the position to supervise their petition drive. Okay, so I'm part of a team. Our petition ended up being challenged, and the challenger claimed that I had only 225 valid signatures. I needed 500. The challenge went on to the Board of Elections, but their report stated that I had 380 valid signatures, an improvement over the objector. Anybody can be an objector. So somebody from our rivals, the rivals of our team, challenged our petitions. So they only came up with 225, but the Board of Elections said that I had 380 valid signatures. An improvement over the objector, but still 120 short of qualification. That report was sent to me from the BOE, Board of Elections, on April 23 on a Saturday via email. I'm giving you a date because it matters over here. These election cases are very tight. We really had 2 months from the time that we put in the petitions to the primary, but they give you only 2 weeks from the time that people file their petitions to go to court, and you don't even know which side is going to win. You don't even know if your petitions are going to be challenged, but at that early date. But they give you 2 weeks, which is a bunch of baloney. We were given a chance to rebut that report to the BOE. So the Board of Elections gives you a chance to fight that. That's also a sham because, well, I didn't explain yet what the major sham is, but okay, so they send you a report on a Saturday, and then that Monday is when you have to put in your rebuttal. If you have to go through 1,000, 1,500 signatures, it's very hard. It's impossible to do that in one day, because you have to go to the Board of Elections. You have to go to their data site and match it according, against their signatures and all that. And okay, so I'll explain later that you have to get that by 3:00 p.m. that Monday. You have to get it by 3:00, and you have to have it in a PDF sent via email. So how do you have it in a PDF? You have to, I mean, a laptop is well, yeah, I guess you could scan. Well, I don't know. Scan. I guess you could scan with a laptop. Okay. Anyway, 3:00. That's a few hours, and I'll show you later that they actually called me to court that same morning. Okay, we were given a chance to rebut that report to the BOE on the following Monday, the 25th, but we couldn't start until after waiting to get a copy of the objection report. Well, that's also a thing. You have to wait. You have to put in for the objection report because it's not ready before then. They send you the report, but then the actual forms where the Board of Elections writes their objections to your petition, that can only happen the next business day. And then to research a voter record, there are roughly 1,300 signatures to see if they qualify, 1,300 in my case. Once we were done with the research, the rebuttal form of nearly 200 pages had to be scanned and sent by email via a PDF file to the BOE, all by 3 p.m. By the way, where I was checking the signatures, that Board of Elections couldn't even give me the email address where to send it to. I wasn't able to do it, and I scanned it over the next day before 12 p.m. Okay, so okay. Some of my rebuttals by referencing the signatures, voting identification number, the VIN. Every signature is connected to a voter record, and that is called a voting identification number, a VIN. Show that voter signatures were really registered when the BOE had classified them as unregistered. In other words, there were actual problems with the work that BOE had done. Their software is deficient, is bad. For instance, if you look up a record under the city, you can not find it. You have to go under Queens, but that's wrong. That's effective. So I actually had 35 signatures that were pristine, that were beautiful. Now I know it doesn't fill up the 120 that I was missing, but there were other ways that easily fixed. Okay, that was because the BOE has problem software. Sometimes when doing a voter or record search, it may not show up and it must be retrieved another way. If I do a search under a name, it may not come up. I have to no, the other way. If I do it under an address, it may not come up. But if I do it under a name, it would come up. Not all the time. It's on and off. Okay. So other rebuttals could show that the objector and the BOE did not connect the signature with the correct VIN. So it's all crazy because they don't have to show an apartment number. So sometimes you have a bunch of names in the same apartment building, and even though they print the name of the signer, they may not be clear. And in other words, there's discretion where the BOE can assume that it belongs to one record and really belongs to another record. That's why I'll show you later in the rebuttal form, the BOE writes the VIN number, and when you want to rebut it, you write a different VIN number. Okay. The original objector writes the thing that's wrong with it, not registered or not a valid signature or whatever. But okay. But sworn affidavits from those who collected the signatures, they're called subscriber witness. Yeah, called subscribing witnesses to explain deficiencies in their statements. So the person who is collecting the petition, the subscribing witness, they have a section at the bottom of the petition to fill out. And if there's any deficiency in their statement, then it can be cured. Now, I was told later that it can be cured even to the Board of Elections, but that you're given a few hours, and how are you going to get people to come over? Because you only found out what the Board of Elections ruling was a couple of days before, on a weekend, in fact. So to get everything in place, to get affidavits from the subscribing witnesses, that next business day is impossible. But anyway, so you can do it in court to explain deficiencies in their statements were impossible to get to the BOE by their ridiculous deadline. Examples of such deficiencies were where a witness had just moved and wrote down on the witness statement their new address, which wasn't registered yet. So a witness writes down on the witness statement, they moved, and they write down their new address, but the new address is not registered yet. So that it doesn't work. You have to explain, no, that witness is good, but that'll go on the old address. Or if a witness wrote down a temporary address that they were not registered at, but are registered with their regular address. One witness was house sitting, and they wrote down the address of the house sitting, the house sitting address. But those constitute eligible witnesses when the deficiency is explained. Also, the BOE sometimes erroneously strikes the whole page of a witness if the witness miscounts the total on that page. This is a crazy thing, totally against the law, that if the witness makes a mistake in how many there are on the page, let's say he writes there are 13, and really there are 14. The Board of Elections and the objector think that you can strike the whole page that the witness, all the signatures on that page. That is wrong. That is not the law. Sometimes the Board of Elections even miscounts the total themselves. So I mean, if there's a signature on there that that the witness knows was not good because the address is wrong, they could just leave it out. But or they can just okay. What I'm saying is the BOE considers that an entry, but the witness knows that he didn't count that, so they're holding that against them, or the BOE can just miscount themselves, whatever. For a remedy to these challenges, when it cannot be done at the BOE, a case is filed with the New York State Supreme Court. So I hired a lawyer to validate my petitions. That's the word. I'm running for office. I'm trying to get on the petition, on the ballot rather. I'm gathering petitions. I'm suing to validate. I'm suing the people that I'm running against, who are on the other side, who are trying to block me. And I'm also suing again, not monetarily, but I'm suing the Board of Elections, that I'm going against them also. Subsequently, I received notice that my political opponent filed a case in court to invalidate my petition. So they're doing it the same thing, but on the opposite side. They're invalidating, because neither side, like I said, because we have to put this in so much in advance, neither of us know what the ruling will be from the Board of Elections. Election law requires that you file a court case no later than 14 days from the time that the petitions were filed with the BOE, which means that at the date of filing, neither side knows yet of the BOE's ruling and in whose favor it will be. So that's what I just said. So both cases were combined by the court, and on April 25th. Okay, so that's the date that I'm supposed to go to the Board of Elections to rebut my the case against them. Meanwhile, I'm already being summoned to court via Zoom, okay, because it was still COVID, whatever. The 25th, that Monday, I'm supposed to be at the Board of Elections checking signatures, and the case, the hearing is already on the docket for that day. The Monday that I was supposed to be at the Board of Elections tracking all of 1,300 signatures and filling out my rebuttal report, I had to attend a virtual hearing for the court at 9:30 a.m. And of course, that's part of the reason that I couldn't finish the rebuttal report by 3 p.m. Okay. I had hired a lawyer. Then I was told that he could not represent me. So I was there on the virtual hearing by myself. So okay, so my lawyer could not represent me in that hearing because he had an overload of cases, but he gave me the number of his acquaintance. By the way, it's very hard at that time with all these cases going to court, because of petitions, to find a lawyer. So, okay, and he was swamped, and he gave me somebody that he knew, Bernard Mitchell Alter, and he goes by the name Mitch. Okay, Mitch is my lawyer. Okay, so who could take on my case on Tuesday? Okay, so we already had one virtual where I explained that I'm not prepared to go to court because I'm not prepared to go forward because I'm not being represented. So Tuesday, the 26th, the BOE had not accepted my, okay, so the next day when I had, okay, so I submitted my rebuttal the next day, Tuesday, had not accepted my rebuttal report because it was filed after their Monday 3 p.m. deadline. And I was deemed off the ballot because I didn't overturn their ruling. They gave me their ruling on a virtual hearing. The BOE also had a virtual hearing then. Tuesday, which I was watching. So they gave me their ruling on a virtual hearing, which I was watching and thought that I could be a part of, But I couldn't even be heard because the BOE had given me the wrong link, and the hearing officials didn't see me in the waiting room. So I asked them for a link. And by the way, when I was in person checking my signatures, they couldn't give me any information, where to get the link, or where to send the PDF of the rebuttal. So I was already given a link after I submitted my rebuttal, but the link was wrong, and I was there watching it. In other words, they gave me the link of a spectator, not that. I mean, it was, they knew I was a candidate. It was on the same submission that I wrote my rebuttal. I said I want a link, but no, they gave me the wrong one, and they couldn't hear me because I wasn't in the quote waiting room. Okay, whatever. Mitch, my lawyer, joined me on a court Zoom meeting the following day, Wednesday, the 27th. I told the judge that I am hiring him to be my lawyer, but that we hadn't signed the retainer yet. But the judge on the case, Tracy Catapano Fox. Why am I mentioning her name? Because I want people to know her name. If she comes up for election, I want people to know what I'm saying and whether they're going to vote for her. Tracy Catapano Fox did speak. Okay, but the judge on my case, Tracy Catapano Fox, did speak to Mitch as my attorney, and I'll refer to that later on. So Mitch came on the Zoom with me, and the judge, Fox, did recognize him as my attorney. The judge assigned us to come to physical court the very next day. So that's already Thursday, April 28th, which was a full 2 months before the primary day of June 28th. Okay, so you'll hear later about, election deadlines, even over here, the panic. Why? Everything. I'll talk about it. Postponement. No, there's no time. This is a full 2 months before the primary date of June 28th. Okay, so we're coming to court the next day. Okay, so now we are allowed in court, despite whatever. I mean, COVID was already, 2022 was already tailing off. The next day, as we appear in court, Mitch asked the judge for an adjournment because he was on my case for just 1 day. So that's the fact that that when he came on that Zoom on the Wednesday, the day before, he said he just got on the case and he didn't yet have certified copies of the registration records needed as evidence. So I told you before about the voter records. Okay, so really what I heard was that we would go, there would be a court-appointed referee. I mean, that's actually what it says on the rebuttal form, but no. Mitch said that he doesn't have certified copies from the BOE, Board of Elections. Nor had he submitted the Bill of Particulars. The Bill of Particulars is your set of evidence, your exhibit, your items of evidence, meaning the nature of the evidence to the opposing side that would have specified getting subpoenaed, certified registration records from the BOE to prove our case. So that refers to the 35 that I say were absolutely pristine records that I could show. There was nothing wrong with them. Okay. Okay, so to make up the other, the other signatures that I had to cure, that would be solved with getting affidavits from the subscribing witnesses, which I did have, not at that time because it was too well. I mean, I asked my lawyer, do I present this? He said, not yet. And anyway, the point is that he had not submitted the bill of particulars, which means what we need, what we're going to present to the other side. Now, like I said, that was after one day of being on my case. So he asked for a postponement. Okay, postponement. I've been a landlord for over 30 years. I know when you go to court, postponements happen all the time, all the time. I mean, we see court cases drag out. Okay, over here it was a 2-month thing, but okay. So I'm going to say later how he was justified, how Mitch was justified in not having it right away. Okay, needless to say that election lawyers during petition submission times are swamped with election work, and that would have explained why he hadn't submitted the paperwork. Mitch also had other cases. I was not his own case. So he didn't get to submit it to the other. There's an electronic file they have to submit. Okay, so he didn't do it the first day. Okay, so actually he had to have done it. He would have to have done it that night because I was with him on the Zoom on a Wednesday. He would have to do it that night to get it in for the next day's early morning. We had like a 10 o'clock or so a court appearance. It wasn't an afternoon thing. He would have to do it that night. Okay. And actually, okay, so I hadn't even settled everything with him that Wednesday. I told the judge, and she accepted it, that he's going to be my attorney, but we hadn't settled it with, retainer, check, so on. Okay, the judge, Tracy Fox, okay, Tracy Catapana Fox, Tracy Fox, we'll call her, questions Mitch why he doesn't have the certified copies, because as she states, the case was filed 10 days before. Okay, so all that means is that when you don't even know what's happening, you have to file the case. You don't know what to file because by that the time of the filing of the case, nobody knows what the ruling will be and in whose favor and so on. I mean, she knew that he wasn't even my lawyer 10 days before. She knew that. Okay, so I mean, I explained to the court that I had a lawyer, and he then told me that he can't represent me. That's also understandable because, like I said, all the lawyers are going crazy. If I want to put it crassly, they're all feeding at the trough at that time. It's a boondoggle for I think that's the right word. It's a great business for the lawyers at that time. They're swamped with work. And okay, so how could my lawyer Mitch do anything 10 days before? She says we put the case on yesterday for another virtual conference to see the status of the case. To see the status of the case, Mitch came on that day. That was the status of the case. Before then, I had a lawyer. He said he could no longer represent me. Nothing bad went on between us, but he was swamped. That's the status of the case. Okay. Mitch explains that he was on my case for less than a full day and references a precedent case, Hollywood versus Layton, where the plaintiff was allowed 3 days. So in this case, I'm the plaintiff. I'm I'm the petitioner. I'm claiming to validate my signatures. Where the plaintiff was allowed 3 days from the BOE's ruling to submit to the other side. Now, the BOE's ruling was on a Tuesday. So Wednesday, Thursday, Friday. This case over here was on Thursday. So he says that's what he was relying on. Mitch, by the way, is an older gentleman. He's 74. He's been around. So he cited this precedent, Hollywood versus Layton. Excuse me. So where the plaintiff was allowed 3 days from the BOE's ruling to submit to the other side the objections, i.e., that is the bill of particulars, and based on that, we would have had an additional day to file those papers, meaning the next day, Friday. So that's why he didn't panic. I mean, I was a little disappointed, but he had a justification. Okay, then attorney Michael Reich, right? Michael Reich is a very prominent attorney from county. He's on the other side. He's representing the objector. He's representing. He is representing the county. Michael Reich, widely known as one of the lawyers working for the Democratic Party for Queens County and the lawyer for my political opponent, objects to say that our whole case should be dismissed because he's a lawyer, Michael Reich, hadn't received from Mitch certain basic paperwork, such as a notice of appearance and an affidavit of service, and that it be dismissed with prejudice, meaning that it couldn't be filed again. So this was pretty crazy stuff. That first of all, that it should be dismissed. Dismissed. You didn't get certain paperwork. Okay. So by the way, he didn't say anything on the virtual. Okay, maybe he was expecting to get it that night, but I mean, he knew that it was a new lawyer. He could say, okay, guess what? I don't have an affidavit of service yet, which would have happened from the old lawyer. And I'll give you a spoiler. A spoiler. Actually, it was filed, but Michael Reich claims that it was under a different file or something. Okay. Mitch argues that the notice of appearance, meaning that the other side would be apprised of my lawyer's appearance. Notice of appearance, it simply means I'm giving notice, the lawyer is saying, I'm giving notice that I will appear in this case. So he did that. That's what he did when he appeared on the Zoom the day before. Meaning that the other side would be apprised of my lawyer's appearance, was known through the Zoom from the day before, and Reich therefore knew to come to court for the case. I mean, Reich was there. He knew he was prepared. He came. I was there. My lawyer was there, and Reich was there. Mitch said that Reich's appearance. My lawyer, Mitch, says that Reich's appearance, the other guy, constituted a waiver for the need of a formal notice. In other words, that he showed up. In other words, he knew that we're having a case. Of course he knew. Okay, so Mitch further argues that the absence of the affidavit of service, okay, so now he's addressing the other thing. The absence of the affidavit of service should have been objected to by Reich when we were in the virtual conference, since even my first lawyer would have filed that. Later to find out that my first lawyer really did file it, according to Reich, applied it to a wrong folder. So Reich answers, okay, so in other words, the question is to Reich, why didn't you say anything that you didn't get an affidavit of service? Reich answers that on the virtual hearing, he couldn't have objected to Mitch because at that point, Mitch was not officially my attorney. until the next day when, quote, Mr. Green, this is what Reich is saying, when Mr. Green, unquote, shows up, meaning the money, in exchange of money. So Reich is calling that Mr. Green. A little bit irreverent as far as I'm concerned to talk that way in front of a judge. Anyway, meaning the money that would be exchanged. But that wasn't the approach, but that wasn't the approach of the judge towards Mitch's appearance, as I noted before, because the judge did speak to my lawyer, Mitch, as my attorney on the Zoom. So if it was good for the judge, it was good enough for Reich to accept him, to engage with him. He could have told him, I didn't get the notice. Okay, you got to give me a notice of appearance. Okay, notice of appearance. Maybe he was expecting that night, even though he already got it through oral. But certainly the affidavit of service, he could say, hey, I didn't get the affidavit of service yet, and this case has been here for a while. Okay. Now I am shocked to hear the minute we walk into court after 20,000 that I will have spent and weeks of petitioning from my campaign that they should so casually and senselessly dismiss my case. On discussion of dismissing my case. I mean, if you're walking with cash, if somebody mugs you and they take $1,000, oh, wow, you know, that's I think that's a grand larceny or aggravated robbery or whatever. It's not. It's $1,000. We're talking over here at this point. I will have spent 20,000 because I had to get the lawyer and whatever else I was spending on the campaign, and that doesn't even include the work that I had done petitioning. I mean, I wasn't the major petitioner, a major petitioner, but I did quite a bit of work. So to be so callous and to just dismiss, get out of here, you know, what is that? I mean, that's really cruel. That's very cruel to cut off somebody's opportunity. And I didn't say it earlier, but I'll say it now, that we all have sympathy for the blacks in the South who weren't allowed to vote. Suppression of the vote is a very serious matter. Well, suppression of the ballot is also a very serious matter. We have to allow people to get on the ballot because otherwise we don't have a free election. If they're cut, and by the way, I'll quote you later from the Daily News that these guys from county, they are there to do their best, their very best. They make it their business to cut people off, to outsiders, from getting on the ballot. Okay, but to my astonishment, Judge Fox grants Reich the dismissal of my validation case that he demanded, that Reich demanded. But she goes on to say that she will not grant him that dismissal with prejudice, meaning that it could be filed again. So, okay, she's actually gonna, because of this, procedural stuff. Notice of appearance. Oh, we don't know that my lawyer is going to be there. Oh, an affidavit of service. Oh, we don't see it. The affidavit of service. Okay, so give us another chance to put an affidavit of service. Excuse me. No, she was going to cut it off. Dismiss the case. It's like if there was a murder case and somebody had not filed notice of appearance. Oh, Mr. Shapiro, we didn't know Mr. Shapiro is gonna represent OJ. Or, oh, you didn't file the affidavit of service? Okay, we're dismissing the case. Okay, we can't convict OJ because there's no affidavit of service over here. No, you give people the chance to cure it. Now, what would happen after a lengthy period where people are not cooperating. I mean, if the prosecutor or the defense, whatever, that's a different story. Over here, this is one day that my lawyer was on the case. Okay, but Reich persists on. Okay, so now Judge Fox granted Reich a dismissal of my case, but not with prejudice. So she did allow the case to be refiled, but now Reich persists on to say that his invalidation case. So you remember there were two cases that were combined here. Well, I didn't tell you that, but they were combined. Originally, there were two cases, and they were brought together here. His invalidation case against me, that case should be granted. Now, how does that work? I was thrown off the ballot, so it's for me to prove that I'm on the ballot. He is saying, okay, his invalidation case should only come up had the BOE ruling been in my favor. Then he's allowed to bring an invalidation case against me, against the Board of Elections, to show, no, we're not going to go by the Board of Election in my favor. No, he's going to show invalidating my petition. But that's not the case. The status quo of the case is that I was off the ballot. The ruling was against me. He's going to jump up and say that his invalidation, which has no bearing over here, no relevance, should be granted. And on what? We didn't even have a chance. We're in the middle of presenting our case. Okay, we have to refile, but we're still in the middle of it. It has not been killed. It has not been killed off. And actually, I should have said that it's, I mean, yes, when I was comparing it to the OJ thing, they killed my case procedurally, but not on the merits. So Tracy Fox, to her credit and discredit, I mean, that she's getting so worked up over this procedural thing from a day not being filed, but she did leave open that we can file again. But now he's jumping up and saying, Reich, that his invalidation case should be granted since we, quote, couldn't go forward with the certified copies. So he's stuck on that we didn't have the certified copies, which Mitch wanted an adjournment for. Okay. Mitch argues that there is no purpose to grant what I just said, that there is no purpose to grant the invalidation case because it's moot, because Fuchs is already off the ballot from the ruling of the BOE. So he's stressing the obvious. I'm off the ballot. We are here to present that I should be on the ballot. So the other side's invalidation case should not be a part of this. It's moot. The point of the court case was to supersede and correct the ruling of the BOE, if that's what the evidence showed. However, Judge Fox takes that argument. Oh, you're off the ballot? Oh, okay. Then I'll grant the invalidation. Takes that argument to support the motion to affirm Reich's case of invalidation because there was no opposition, because I could not oppose his invalidation because we don't have the certified records. So she's going to grant him that. No evidence. There's no opposition, meaning no evidence to prove that I should be on the ballot, acting as if adjournment was never requested to acquire through a subpoena, because you can't just, according to my lawyer, Mitch, you can't just go to the Board of Elections and get this. I mean, you can, but the court needs certified copies. I'm sorry, you can get certified copies, but it has to be through a subpoena because it has to come from them directly. It can't come from you going into the Board of Elections and getting certified copies. So acting as if adjournment was never requested to acquire through a subpoena the certified registration cards. But she goes on to say to our side, but that does not preclude you from proceeding under the statute, meaning we can retry our case. Okay, so, you know, kind of a mixed bag over here. She's throwing them a victory that they won their invalidation, and yet we can go ahead refiling our validation. That's going to be a problem if we win. I'll say later, if we win, we're going to have two opposing things, two opposing rulings, and how do you work it from there? Okay. Subsequently, the judge will go on to file two reports for the two cases, for the invalidate and for the validate. Invalidate and the validate cases. She dismisses the validate case for procedural deficiencies, i.e. not filing a notice of appearance, an affidavit of service, as I said, as I explained, upon the other side, and grants the Reich's invalidate case on the merits, to invalidate my petition because we hadn't produced the certified records. Again, I state, ignoring our legitimate request for a first appearance postponement. That would have been a first. I just realized that this cursor was in the middle of the screen. It was our first appearance in court, our first appearance postponement. The other one, the Zoom, were just, as the judge said, to see the status, to lay out what we're doing. Okay. So besides all this irrational reasoning, this is really an incoherent contradiction. This is really an inherent contradiction, because how does the judge grant my opponent's case to invalidate and then leave open that we can retry the validate case? If we prevail with our validate case, wouldn't there be opposing cases, the invalidate and the validate, both granted by the court? How do you have both? How do you have rulings to both? Contradictory thing by the same judge, an invalidate case and a validate. If we win, we would validate, and yet the other side it remains as an invalidate. Because how do we knock off the other side? That was a ruling from the other to the other side. That was an invalidate. Nevertheless, Mitch proceeds to open a new case to validate, my case to validate, where all the missing paperwork from the first case, including a bill of particulars, in other words, to show all the evidence, we will have to subpoena the Board of Elections for their certified records, along with my original petition, the whole stack of petitions, and my rebuttal form with my notations to the BOE. Excuse me, and my rebuttal form with the notations to the BOE. In other words, if I write a new VIN number, that's going to be on the rebuttal form, is presented to the other side. So now Mitch really jumped on it and submitted all this stuff to the other side. The new case falls on the docket of Judge Robert Colares. Michael Reich, from the lawyer from the other side, then proceeds to argue that Colares should not hear this new case, my new case with Colares, because the invalidation case was granted. So now this is where we see, this is the method to his madness. Why did he stick in his invalidation case? Because he wanted that to lord over my validation case, and I'll flesh it out in a few minutes. the new judge should not hear the case that we refiled, my validate case, because his invalidate case was already granted, and I was deemed to be off the ballot on the merits. So if it's on the merits, how do I fight that? How do I fight that if his case is on the merits? Okay, so Mitch counters, my guy counters that the validate case was dismissed procedurally because Fox stated that that does not preclude you from proceeding under the statute, and that we can proceed with our case. So yeah, your invalidate case was granted on the merits, but our case was dismissed only procedurally, so we should be allowed to proceed. Judge Claris then takes time to read the reports by Judge Fox. So Judge Fox actually wrote reports for the two cases, for the invalidate and the validate. Claris rules that since Fox granted the invalidate case on the merits, because we, quote, didn't have the certified registration cards, unquote, the proceeding of our validate case should not go forward. It should not go forward, he reasons. It did not go forward because he reasons if we couldn't produce the certified registration cards to oppose the invalidate case, that means that we didn't have the registration cards to validate our case, because he says the issues and the evidence are the same. He's saying we didn't have the cards, the registration cards to fight the invalidator. So why should he hear our validate? We didn't have the registration card. This is ridiculous reasoning for the following reasons. Okay. Judge Claris is playing a game here, because even though the evidence is the same, the issue is not the same. Fox dismissed the validate case only procedurally and not on the merits. Not on the merits. So how can Claris then say that Fox's ruling is such that we could proceed with it only as a sterile action, only to be shot down once it is revived? In other words, he's not overruling. This is not an appeals case. He's not overruling Fox to say that she doesn't, what she said is wrong, that we can refile. So if we can refile and it's revived, then Claris says that it doesn't matter, that since the invalidate case was already established, then her case can no longer be heard. But she said it can be refiled. So what is that? She meant it can be refiled as a sterile action, that with no consequence. It can be refiled, but once you refile it, it's nothing. It ended up in the garbage. So I'm saying, how can Claris say that she said, yeah, go ahead, refile a sterile case? Makes no sense at all. If the prior ruling of the invalidate case is dominant over the validate case, it was totally meaningless of Fox to say that we could revive the validate case. You cannot make the invalidate case dominant, because if you do that, it means that you can no longer file the validate case. It makes it totally pointless. Okay. Judge Claris refers often to the Latin term res judicata. He's explaining, which means, quote, a matter that has been adjudicated by a competent court and may not be pursued further by the same parties. Well, that makes sense. You have a case that was ruled on, and you cannot just bring the same action again unless you go to a higher level of appeals. But you can't bring it on the same level. You can't just refile it because it's been adjudicated. That's what res judicata means. A matter that has been adjudicated by a competent court and may not be pursued further by the same parties. Collaris stresses in his ruling that we had a, quote, full and fair trial, unquote. I used to watch Ally McBeal, and they had a laugh track when somebody said something ridiculous in court. This calls for that laugh track. We had a full and fair trial? No, we did not have a full and fair trial. The evidence was not allowed in because of procedural matters that Judge Fox said we have a right to refile. No, Judge Collaris, we did not have a full and fair trial. And our petition, and he says, our petition was deemed to be insufficient because we couldn't produce the certified copies. Duh, right. We acknowledged that. We asked for a postponement because we were going to get the certified copy. We were going to subpoena them. Not good enough to go into court and I'm sorry, the BOE and get the copies. Has to come through a subpoena because it can't break the chain of custody. I can't go. They're afraid that I'm going to tarnish them or something. Full and fair trial? No. Maybe it would qualify as that. I write over here. That's my comment in a Russian court. That trial that we had where we were thrown out because of a notice of appearance and affidavit of service, and not to allow a postponement, even though Hollywood versus Layton allows the extra day, that would have qualified for a full and fair trial in a Russian court. Okay, but even Collaris knows that what he is saying is specious because we didn't say that we permanently don't have the certified copies. We just asked for an adjournment to get them. So, no. Okay, so if we ask for a postponement, how does he answer that? So he explains that by saying that with the constraints of elections, it's elections, there's such hard deadlines. There was no more time to extend to allow for the obtaining of the certified copies. That one day to put into the other side, we're doing a subpoena. No, that would have been no good. Constraints of elections, this was a full 2 months before the primary. What about Mitch's reference to Hollywood versus Layton that allowed 3 days from the BOE ruling to obtain the bill of particulars? Nobody answers that. Nobody answers that. Maybe that is why even Judge Fox did allow the Validate case to proceed. So at least she didn't, I mean, maybe had we gone past that, she would have thrown it out on the merits that you got, it was past 3 days. But no, she didn't do that. She didn't throw it out on the merits. Maybe she didn't mention it, and maybe because she is factoring in that we had another day. Okay. Perhaps then with the 2 opposing rulings, she could have ruled in favor of the one that prevails over the other. So, I mean, I don't know how Judge Fox was going to do these 2 opposing rulings. First, to set up prematurely the invalidate, and then maybe later she would have made one dominant over the other. If we come in with the evidence, she would have made our case of validate dominant over the invalidate. So by what authority does Collaris have to disregard her green lighting of the validate case? Collaris is really just stepping all over the first judge by throwing out the case, that it cannot be filed again when she said it can be filed again, it should not be subservient to the invalidate case. His whole res judicata, that it was trialed, that it was tried already, full and fair trial, it's a bunch of baloney. No. So we appeal Colaris's ruling. And the answer comes back that our case is denied. Okay? The appeals court does not rule in our favor. Here's the clincher. But for a different reason that Colaris provided. That means that Judge Colaris's reason for dismissing our case was wrong. The appeals court actually said that Colaris is wrong, but they're going to deny my case anyway for a different reason. The appellate judges are, and here I'm noting their names because I want people to know about them also. Colleen Duffy, Francesca Connolly, Linda Christopher, and William Lloyd, William Ford. They write, this is the appellate judges, we affirm Colaris's denial for different reasons from those relied upon by the Supreme Court. Colaris, meaning Colaris. I didn't even know such a thing is permissible. And it shouldn't be, because the purpose of an appeal is to appeal the prior ruling. I didn't know you can say the lower judge is wrong, but we're going to deny your case anyway for a different reason. A different reason, stuff that I wasn't even given the chance to argue about. If it's a different reason, my lawyer and I couldn't say anything about it. We were just addressing what the lower court did. Colaris, his wrong reasoning. I don't want to say stupid. I want to be a little respectful, but really, in my opinion, it was stupid or corrupt, like I started out by saying. This res judicata, full and fair trial. How can you say that? Okay. Because the purpose of an appeal is to appeal the prior ruling. The reasoning of the prior ruling should stand up to scrutiny, and if it doesn't, the ruling should be discarded. That the ruling, if the reasoning is wrong by the lower court, to my way of thinking, the ruling of that lower court should be thrown out, because you can't argue against other reasons that were not brought up earlier. The appeals ruling, okay. So now they're going to explain why they're denying my case, even though Colaris is wrong. The appeals ruling goes on to say that our supporting exhibits were not sufficiently particularized to support Fuchs's contention that the BOE improperly invalidated his petition, unquote. So they're going to question my exhibit. What exhibit? The exhibit of the rebuttal form. But in our exhibits, we did submit the rebuttal on the very same form that we received from the original objection, that we received with the original objection abbreviations. That rebuttal form was given to us by the Board of Elections. It's the same one that the objector uses, and the same rebuttal form that, by the way, there was no column for us. There's no candidate column for us to write our notations. It says a court appointed referee in that column, but we didn't even get to the referee yet. That's what the Board of Elections gives you, a rebuttal form that doesn't even have a column for the candidate to rebut the other rulings. So we did submit the rebuttal on the very same form that we received with the original objection, abbreviations, because the objector has abbreviations, like not registered as NR. There are a million of them, but anyway, with the original objection abbreviation from the objector, and the BOE's circling of those abbreviations. That's how you know that the BOE agrees with the objector when the BOE circles the abbreviations of the original objector. And their reference to a VIN. So that's what we got. We got the objector, they write their abbreviations, and the BOE with the VIN, and then we would write another VIN showing which VIN we feel that voter record should be connected to, associated with. Our rebuttal on the form was that of a corrected VIN, or VIN provided where the BOE had not provided one, along with notes that would reference witness explanations to be followed up in court. Next to each signature we felt was improperly invalidated. So that's what we did on the rebuttal form. But of course, the only way to explain with specificity how they were wrong is by producing, through a subpoena, the certified registration records and affidavits of witnesses which were noted in our bill of particulars. We wrote in the bill of particulars on the rebuttal form that we will have affidavits of witnesses. The rub here is that we were precluded from showing that by Claris, the second judge. In other words, we weren't even allowed to proceed with this evidence because he wouldn't let it proceed based on his interpretation of res judicata that he applied incorrectly to this case. In other words, the appeal judges are saying we didn't flesh out the rebuttal form, the bill of particulars, but Judge Claris didn't even allow that. It was submitted, but he didn't allow that to go on to anything. Anything that Judge Claris would have asked us, we would have provided him, but we submitted that initial rebuttal form with VIN numbers and notations about affidavits for the subscribing witnesses, but Claris didn't let it to go, didn't allow it to proceed further. So we appeal again. So this is the second appeal we're going to do, the very last appeal possible, upstate New York and Albany. And this time the verdict comes back with one word: denied. Denied. That's their whole explanation. Denied. So here I want to give the upshot. The upshot of this proceeding is that the court exaggerated any flaw they could to render a dismissal of my case. Not to allow a virtual hearing notice, not to allow virtual hearing notice of appearance. Yeah, not to allow a virtual hearing notice of appearance to at least temporarily stand in for a formal notice. In other words, there was a notice of appearance at the virtual hearing, not in writing, orally. No, not to allow that. They didn't allow that. To have allowed the excuse from my opponent's attorney for not stating an objection at the virtual hearing that he hadn't seen the affidavit of service because he didn't consider the attorney present with me to be my attorney of record, when the judge did recognize my attorney to be that. So there, Judge Fox allowed Michael Reich to say that he didn't consider my lawyer the attorney of record, when the judge did consider my attorney to be my attorney of record, even though we hadn't signed the papers yet. Not to allow first-time postponement for an extra day, to allow for the certified records subpoena to be submitted to the court, as per my attorney's argument precedent of Hollywood versus Layton. to render a ruling for the other side when it was the ruling of the BOE already. In other words, this whole business about making an invalidate case a ruling by the court, when that was the ruling already, that was not the purpose of the case. That was totally, just redundant, redundant, therefore not to the point. And therefore, that moment essentially moot. That let me say this again: to render rulings for the other side when it was the ruling of the BOE already, that I was off the ballot, and therefore that moment essentially moot. That issue was moot. That was established already, and of no consequence to the court other than to be held up as a bogus res judicata argument. In other words, I'm saying that Michael Reich knew that Calaris could use it as a res judicata, that to make it as if we already argued that case, when that case was not argued. We were in the middle of our case, and his case was totally redundant and not applicable, non-applicable, not to relitigate a previously issued of a full and fair trial. Well, I'm saying Michael Reich made it through in that invalidate case, so that the next judge will be able to say, hey, it was already ruled on the merits, because that's what Tracy Fox did. One on the merits, on the invalidate case, and procedurally on our case. Totally ridiculous, totally, that whole thing. Totally chaotic and makes no sense at all why she allowed that other invalidate case on the merits to be established. So I'm saying Michael Reich probably knew. I'm sure he's done that method before. For the time we open up our case again. So he threw that invalidate case to make it a res judicata argument for the new judge that they shouldn't hear our case. Not to hold off ruling for either side until we had a chance to refile our case. That would be the normal thing. Not, in other words, to hold off a ruling for either side, for the other side too, until we had a chance to refile our case, which in fact this very judge had authorized us to do. Tracy Fox authorized us to file another case, but not to hold off. That's funny business. That's a kangaroo court. For the appellate judges to fabricate the idea that we didn't particularize our responses. We did what the other entities did on that rebuttal form. We didn't particularize our response on the rebuttal form when we reference a correct VIN of the registration card, which is what the BOE had done to prove their case, aside from circling the abbreviated deficiency code of the objector. So what the BOE had done was they write a VIN number, and they also circle the abbreviation of the deficiency from the objector that the objector wrote. That's what the BOE did on that same rebuttal form. So what are we supposed to do? Uncircle the objector's thing? No, we write the VIN number, and next to the subscribing witness section, we write our notation. Will testify in court, affidavit, etc. So by our referencing a different VIN, it would have automatically rebutted the deficiency that the BOE had designated by directing them to the proper registration card, which ultimately we were not permitted the extra day to submit to the court. That's all that was needed. We wanted an extra day. That the appellate judges would not have permitted us a second chance. Yeah, so now I'm talking about the appellate judges. What's with them? That they didn't, I mean, to jump on this lack of particularity. If there's a problem with the paperwork, you give us a chance, a second chance to cure that lack of particularity, even if it's true that's considered a deficient paperwork. By allowing us to perfect the rebuttal according to their specifications. Obviously, everything would have been filled in. The registration cards, pristine records, 35 affidavits. I got affidavits from all the subscribing witnesses. They were perfectly good subscribing witnesses, just different things, miscount, baloney, that you throw out the whole thing, whatever, but they would explain why they didn't count certain things. But the problems with the addresses, those affidavits would be on the record had they allowed us to present them. But that's a matter of, we submitted the original rebuttal. This is what we're going to do. So they didn't allow us to proceed, to go on, to have that further evidence in the case. The idea that the second appellate court does not feel obligated to explain the ruling. So the second appellate didn't explain anything. They just wrote denied. If I'm a taxpayer, I'd like to know why they don't have to explain what they're saying. All of these things point to corruption of the law in the sense that true justice was not sought in this case, but rather a draconian proceeding which denies justice to a candidate who legitimately should be heard to validate his petitions. This can only be practiced in the shadows, when the populace doesn't know of this ugly side of the election process. Sadly, too many people are not actively involved in voting, but for those who do, this knowledge of denied ballot access would surely make a difference. These crooked proceedings, devoid of true justice, that's what I'm considering, the crooked proceedings, that there was no real justice in this case, have to be made public so that those who do care can channel their energy to demand a change. So really, in another piece that I didn't include here, another article I wrote about this, that these lawyers from county were written up in the Daily News as having a lot of power over judges, that the county and by extension these lawyers who represent county are promoting these judges, and the judges have a conflict of interest to go against county, go against these lawyers. So that's why, in my opinion, this came out the way it did. Corruption. So now when you hear that there were 60 rulings against Trump, you'll know that not everything is so glorious in a court of law. Thank you.